Hello. So ito, good evening sa inyo. So another discussion tayo. Tatapusin natin tong revised corporation code within this week. Yung ibang parts ng kasi we will discuss until at least at most so title 15 kasi yung ibang titles na doon yung mga proceeding succeeding titles after title 15 medyo irrelevant na siya. Hoy, hiri. So, for this night or for this session or for this video, we will discuss chapter at section title 11 and title 12 ng Revised Corporation Code of the Philippines. So, ngayon ina-announce ko na yung final exam natin. Wag mo na final exam. Anong dates ba to? Ngayong ating na yung ating final exam. Long quiz muna. Ang ating long quiz will be on dilan pa ako. January 15. Ready? Oo, January 15. Tapos yung finals natin will be on January 22. Final exam natin January 22. Last long quiz natin January 15. Tapos of course, don't forget to submit your yung pinapagawa ko sa inyong project for the corporate, yung create your own corporation. So with that said, let us start with our discussion. So ito, Title 11, Non-Stock Corporation. So, di ba? Basically, mga pinagsabi natin last time pa are most generally about stock corporations. Now, we will go to non-stock corporations. Lirik, makulit kang pusa. So ito. Singog ka dito. Say hi. Hi. Baba. Aral tayo dito. So ito, let's start with section 86. So sabi dito, alcohol muna. For purposes of this code and subject to its provision on dissolution, a non-stock corporation is one where no part of its income is distributable as dividends to its members. Kasi alam na, or trustees or officers. Diba sa stock corporation, tayo ng dividends. Provided that any profit which a non-stock corporation may obtain incidental, tandaan nyo, incidental to its operation, shall, whenever necessary or proper, be used for the furtherance of its purpose or for the purpose or purposes for which the corporation was organized at the first place, subject to the provisions of this title. Now, the provisions governing stock corporations, whenever pertinent, shall be applicable naman dito pagdating sa non-stock corporation except as may be covered by specific provisions of this title. So kung may mga hindi naman yung mga provisions ng stock corporation applicable sa non-stock. Pero kapag may specific provisions yung title 11 in regards to non-stock corporation, yun ang ifa-follow. Kasi of course, at the first place, different. Magkaiba si non-stock at si stock corporation. Now, Section 87 provides for the purposes of non-stock corporation, for which non-stock corporation may be formed or organized for charitable, mga charitable, religious, educational, gaya ng ADSU, non-stock yun, professional, cultural, fraternal, literary, scientific, social, civic services, or similar purposes, like trade, industry, agricultural, and like chambers, or any combination thereof, subject to the special provisions of this title governing particular classes of non-stock corporation. So yan yung purpose niya. And ito yung mga example ng mga non-stock corporation that is organized under our laws. Bumalik. So, definition of non-stock corporation is provided naman sa Section 86. And it refers only to ordinary non-stock corporation formed for any purposes mentioned in Section 87. So ito. Excuse me po. Definition ng non-stock corporation. Yeah? Tapos itong title na to, maikli lang to. So maikli rin yung discussion natin for this title kasi napaka-straightforward ng Title 11. So the power to make profits and engage in business. So as we have said, pag incidental profits, basically, generally, bawal. mag-engage in business ang isang non-stock corporation kasi hindi naman talaga yung kanyang purpose, di ba? Ang purpose niya hindi para kumita, para maging or para tumulong basically. Parang foundation ganon. So, hindi siya pwedeng mag-engage sa business. Pero kapag may incidental income siya from its operation, okay lang 'yun, goods lang 'yun. Pero sabi ng batas, required ang non-stock corporation na gamitin 'yun sa kanyang expenditure, sa kanyang mga gastos. Hindi niya pwedeng gamitin 'yun para ibulsa, para kitain. Kailangan niya 'yun i-reinvest sa kanyang operations for its purposes, 'di ba? Basically 'yun. Incidental profits obtained from its operations, goods lang. Ngayon, paano naman pagdating sa accumulated funds? Anong gagawin diyan? May naipon ang isang non-stock corporation. Anong gagawin niya doon? Well, basically pwede niya hindi siya pwede mag-engage sa business, pero pwede niya yung i-invest sa gawin niya yung investment kumbaga. Oo, pwede siyang bumili ng stocks. Doon, gawin niyang investment or sa mga mutual funds. Yun, pwede niya yung gawin. Or sa mga bonds, yun, pwede niya yung gawin. Like a very good example of that is yung Catholic Church of the Philippines. Pati yung other groups niya. Ang dami sa kanila, malalaki yung investments in the big companies. Kaya sa San Miguel, malaki ang investment ng Catholic Church yan. Sa BPI, Bank of the Philippine Islands. So, di ba? Ang Catholic Church is a non-stock corporation. Pero pwede yung accumulated funds niya, pwede niyang invest. In this case, yung Catholic Church ini-invest sa stocks ng big companies dito sa Pilipinas. So, yan. Okay, generally, bawal silang mag-engage in business for profit. Pero if may incidental income sila from their operations, okay lang yun. Goods. Pero kailangan nila yung i-reinvest into their operations. Ibalik nila. Gamitin nila. Hindi nila pwede distribute as dividends sa kanilang mga members. Ngayon, pag may accumulated funds sila, may naipon sila, pwede nila yung gamitin as investment. In this case, sa bonds, sa stocks, sa mutual funds, pwede. A good example, Catholic Church of the Philippines. Now, applicable provisions, kaya nasabi natin, non-stock corporation shall be governed by Title 9, etc., etc. Yung mga provisions of the stock corporation, if applicable sa non-stock, goods lang. Pero pag may specific provisions yung non-stock, yun ang gagamitin. So ito, Chapter 1, members. Diba? Sa stock corporation, while we were discussing stock corporation, always natin na mention yung mga stockholders or members. Ito naman, we will now focus on members. So the right to vote. The right to vote to the members is provided by Section 88. So the right of the members of any class or classes to vote may be limited, broadened, or denied to the extent specified sa Articles of Incorporation or sa bylaws ng non-stock. Now, unless so limited, broadened, or denied, each member, regardless of class, shall be entitled to one vote. So dito, kahit sa non-stock corporations, yung mga members, meron tayong classifications na pwedeng gawin. May mga types, di ba? Like sa stock corporation, meron tayong ordinary shares -A, ordinary shares -1, or ordinary shares number 1, ganun, di ba? Or meron rin tayo sa preference shares. Dito sa sa non-stock corporation, pwede rin tayo mag-classify. Like member -A, ito lang yung kanyang rights. Member -B, ito yung mga rights niya, pero wala siyang right to vote. Member -C, yung vote niya pwede siyang yung power ng vote niya is entitled to 2 votes. Yan. Pwede mag-classify dito. Now, unless otherwise provided in the Articles of Incorporation or sa bylaws na to, a member may vote by proxy in accordance with the provisions of this code. Kasi kahit sa stock corporation, proxy pwede. Now, the bylaws may likewise authorize voting through remote communication or in absentia. So, hindi lang sa stock corporation pwedeng remote communication. Mag-Skype, mag-Zoom, mag-email, pwede rin, applicable rin sa non-stock corporation as long as provided naman ang bylaws niya. Which is same din sa stock corporation. So, ito, salient changes. Napaka-straightforward ng Title 9. Hindi to maikling discussion lang to. So, non-transferability of members. sabi ni Section 89, membership in a non-stock corporation and all rights arising therefrom are personal in nature and non-transferable unless yung articles of incorporation nito o yung bylaws nito otherwise provided. So, general rule, hindi siya transferable kasi personal yan eh. Personal in nature. Pero pag provided naman sa AOI, sa bylaws, okay, transferable. So, napaka-straightforward. Now, paano na-terminate yung membership ng corporation? Membership shall be terminated in the manner and for the causes provided sa articles of incorporation or sa bylaws na to. Now, termination of membership shall extinguish all rights of a member in a corporation or in its property. Like, anong example, sir? Like, for example, meron nagpahiram ka ng property sa non-stock corporation kung saan member ka para gamitin ito sa operations nito pero tinerminate yung membership mo. So, kahit na tinerminate yung membership mo, unless otherwise provided sa articles of incorporation o sa bylaws, may karapatan ka pa rin sa properties na yun. Okay? Ito, Chapter 2, Trustees and Officers. Diba? Sa stock corporation, directors and officers, ito trustees ang tawag natin. Nasabi dito, election and term of trustees. The number of trustees shall be fixed sa articles of incorporation or sa bylaws. So, which may or may not be more than 15. No. Itong 15 na number to sa stock corporation, ito na-mention naman natin to last time, sa stock corporations, dati 15 lang yung max rin. Same dito sa non-stock. Pero dun sa stock corporation, binago nila. I think tinasa dinamihan nila, 'di ba? Pero pagdating dito sa non-stock, 15 lang. Minintay nila. Now, they shall hold office for not more than 3 years until their successors are elected and qualified. Trustees elected to fill vacancies occurring before the expiration of a particular term shall hold office only for the unexpired period. So, kapag nag-substitute ka lang, finil mo lang yung vacancy, hindi mo matatanggap yung 3 years na term. But rather, you will only hold office for the unexpired term. So, kapag like for example, yung vacancy was because sa death, tapos 2 years pa lang siya nag-serve, tapos ikaw, inelect ka to fill the vacancy, now you will only serve for the remaining 1 year. Kasi substitute ka lang eh. Panakip butas pa. Oh. Except with respect to independent trustees or of non-stock corporation. So, pati dito. Pati sa non-stock, meron tayong independent trustees, di ba? Sa stock corporations, meron din tayong independent directors. Vested with public interest, only a member of the corporation shall be elected as a trustee. So, ito sila. Kahit hindi sila members, mga hindi to sila members, na-elect sila kasi independent sila eh. Dapat independent sila. Pero then for the remaining part, yung mga members lang ang pwede maging trustee. Now, unless otherwise provided sa articles of incorporation or sa bylaws, the members may directly elect officers of a non-stock corporation. Kasi as we have said, di ba? Mas malaki yung operation, usually mas malaki yung operations ng mga stock corporations, mga big yan sila. Itong mga non-stock, mga medium size lang yan sila. So, pwede dito, sabi dito, na if unless otherwise provided, pwede ang mga members mag-elect directly ng officers ng non-stock. So, hindi lang trustees, pwede rin silang mag-elect ng officers. O to, salient points and changes na nangyari as compared to the old code. So, sa RCC provides the trustee of a non-stock corporation shall hold office not more than 3 years until successors are elected and qualified. Ito, removal of the requirement that 1/3 of the trustees. Ito yung nakabwisit na i-discuss sa revised corp code namin. Kasi ito, that 1/3 of the trustees term of office shall expire every year. Kasi ngayon, straightforward. Pag na-elect ka, 3 years ka. 3 years ang term mo. Pero pag nag-fill ka lang ng vacancy, then unexpired period lang yung term mo. Kasi dati itong nakakainis 1/3. So, for this year, bagong election. For next year, bagong election. For next year, bagong election. 1/3 yan. Nakakainis yan. Magulo yan masyado. So, ngayon, sinimplify yung batas. Basta na-elect ka, 3 years term mo. Pero pag nag-fill ka lang ng vacancy, then, yun unexpired term lang ang term mo. The RCC provides that independent trustees, not members of the non-stock corporation, can be elected if and only if the corporation is vested with public interest. Ito, gaya na sabi natin, no? The first trustees elected in a non-stock corporation does not have to serve their initial terms partially. Oo, itong one-third na lang yan, nag-a-apply lang yan sa tawag dito, sa initial terms. Kapag, for example, yung corporation na, non-stock corporation na pinasok mo, 10 years na nag-ano, hindi ka affected nito. Pero 3 years pa rin yung term mo. Sir, medyo naguguluhan kami. Ganito yan. Kapag, pero useless naman to i-discuss sa inyo kasi old law to eh. Pero tawag dito is staggering. Parang staggering. Ganun. Kaya nga sabi ko nakakahilo to kasi nakakainis to basahin. Kasi, tiyan mo, first year, 1/3 of the board ang, 2 years for the, for the other 1/3 and 3 years for the rest. Kasi pag ito na follow, ibig sabihin, after 1 year, okay, elect ng bagong Pagka second year, okay, elect ulit. Pagka third year, elect ulit. O pagka next year, yung, ito naman, elect na naman. Tapos elect na naman. So every year, may election. Pero sabi dito sa bagong batas natin, basta na na-elect ka, automatic 3 years ka. Kahit na initial pa yan. Kahit na initial term pa yan. Oo. Kaya, hindi na magulo. Straightforward na. Tinanggal na tong nakakahilo. Now, independent trustees of non-stock corporation vested with public interest need not to be a member. Oo. Ganyan sabi ito, paulit-ulit yan. Kasi importante yan. So ito, section 92, which talks about the list of members and proxies, place of meeting. So, napakasimple. The corporation shall at all times keep a list of its members and their proxies in the form the commission, the Securities and Exchange Commission may require. The list shall be updated to reflect the members and proxies of record 20 days prior to any scheduled election. The bylaws may provide that the members of the non-stock corporation may hold their regular special meeting at any place, even outside the place where the principal office of the corporation is located. As you can see here. May difference siya pagdating sa non-stock. Pagdating sa stock corporation. Sa meetings ng stockholders. Kasi dito, yung meetings ng members, at any place even outside the place ng principal office ng corporation. Provided that proper notice is sent to all members indicating the date, time, and place of the meeting, provided further that the place of meeting shall be, ito lang, within Philippine territory. So, goods lang. Ito, non-stock, admitted 20 days, list of members, napaka-straightforward. Distribution of assets, ito. Paano ang distribution ng assets ng isang non-stock corporation? May similarities din pagdating sa stock corporation. Kasi ito ang distribution niya. The assets of a non-stock corporation undergoing the process of dissolution for reasons other than those set forth in Section 139 of this code, ito Section 139 sa dissolution title na yan, shall be applied and distributed as follows. So ito yung priority or list of priority ng pag-distribute ng assets ng non-stock corporation na dissolve na. So ito, as you can see, all liabilities and obligations of the corporation shall be paid, satisfied and discharged, or adequate provision shall be made. Therefore, so ibig sabihin, outside creditors muna, bayaran muna sila. Ng mga bangko or basta kung kanino sila may utang. Now, assets, pangalawa, the second list sa priority, assets held by the corporation upon the condition of returning, requiring return, transfer of conveyance, and which condition occurs by reason of the dissolution, shall be returned, transferred, or conveyed in accordance with such requirement. For example, itong si member nagpahiram ng kotse sa corporation. And since na-dissolve na yung corporation, pero sa pa rin may-ari, yung use of frac nun, yung right to enjoy nun, right to use, pinahiram niya lang sa corporation. No? Upon dissolution of the corporation, then isasauli yun sa member. Kasi yung ownership na kay member pa rin, pinagamit niya lang on a use of frac basis yung kotse na yun. Ito naman, assets received and held by the corporation subject to limitations permitting their use only for charitable, religious, benevolent, educational, or similar purposes, but not held upon a condition requiring return, transfer, or conveyance, by reason of the dissolution shall be transferred or conveyed to one or more corporations, societies, or organizations engaged in activities in the Philippines substantially similar to those of the dissolving corporation according to a plan of distribution adopted pursuant to this chapter. Anong meaning yan, sir? Basically, ganito. Let's say, itong si Animal Foundation, may mga cages siya that is specifically stated sa agreement na gagamitin lang to house animals. Hindi siya pwede gamitin sa kahit anumang purposes. It is only to house animals, mga pusa, mga aso. Kaso, unfortunately, this Animal Foundation nag-dissolve. So, yung mga cages na yun, since ang pinag-usapan lang is yung mga cages na yun is gagamitin lang to house the animals kasi subject to limitations pertaining their use for charitable, etc., or similar purposes. So, yung mga cages na yun, and there's another stipulation na there's no condition of returning them, transfer, conveyance by reason of dissolution. Basically, ang gagawin na lang nila doon, since limit, i-donate na lang nila. Ita-transfer na lang nila. So, to other animal foundations na hindi na-dissolve. Hindi na-dissolve. Na still operating. So, yan. Kasi dito, may condition of returning, transfer, conveyance. Dito may limitations. Na walang condition of returning, transfer, conveyance, and pwede lang gamitin kung ano may purpose na pinag-usapan at the first place. So, example natin, yung cages for animal. O sige, transfer nila to other animal foundations, non-stock corporation, para sila yung gagamit na gawing housing rin for the animals that they have or they will have in the future. So, ganun. Assets, letter D tayo. Assets other than those mentioned in the preceding paragraph, if any, shall be distributed in accordance with the provisions of the Articles of Incorporation or ng bylaws to the extent that the AOI or the bylaws determine the distributive rights. Ito na. May marireceive yung members dito. Pag na-fulfill na itong ABC, then, as provided, may marireceive yung members, their distributive rights or any class or classes of members or provided for distribution. Lahat ba ng members makaka-receive? Depende. Baka, depende sa answer. Baka kasi may mga types of members na na-classify sa Articles of Incorporation sa bylaws na walang rights, walang distributive rights as to the dissolution and liquidation of the non-stock corporation. Kapag ganun, tinanggalan sila ng rights na yun, so wala silang karapatan makareceive. Yung mga members lang na may distributive rights. Okay? And letter E, in any other cases, in any other case, assets may be distributed to such persons, societies, organizations, or corporations, whether or not organized for profit, as may be specified in a plan of distribution adopted pursuant to this chapter. So binigyan ng dito, liberty, yung non-stock corporation, yung dissolving non-stock corporation na i-distribute, i-transfer yung mga assets nila. Pero take note, yung mga assets lang na walang caveat, walang mga conditions, walang mga limitations provided. Okay? So ito yung salient points, provide a distribution of, provide a distribution of assets will be subjected to section 139. So, ifa-follow talaga dito. So, ito, basically, anong pag-usapan dito? Plan of distributions of assets, section 94. So, dito, as subject sa, sabi dito, according to a plan of distribution adopted pursuant to this chapter, ito yon. Pwede na silang gumawa ng plano. Yung dissolving non-stock corporation, pwede silang gumawa ng plano paano yung distribution of assets. Pero take note, kailangan muna nilang masatisfy ito. Yung may conditions. Tsaka sila, yung mga remaining, yung mga residual assets na pwede nilang i-distribute, then yun yung magiging subject to the plan of distribution. Kasi yun na lang pwedeng galawin nila eh. Walang lien overdose. So, a plan providing for the distribution of assets consistent with the provisions of this title may be adopted by the non-stock corporation in the process of its dissolution in the following manner. Yung Board of Trustees ito, by a majority vote, may adopt a resolution recommending the plan of distribution and directing the submission thereof to a vote at a regular or special meeting of members having voting rights. So, yung Board of Trustees, gagawa sila ng plan of distribution. Pagbobotohan nila. Pag in-approve nila, then they will subject it to the approval ng members ng non-stock corporation. So, each member entitled to vote shall be given a written notice about that, about the plan of distribution. Pagdating sa such plan of distribution shall be adopted upon approval of at least 2/3. So, kailangan ng approval. So, dito makita nyo, majority, 2/3. Majority ng Board of Trustees, 2/3 ng members. So, ito rules that is only applicable to non-stock corporation. The specific rules that follows governing a non-stock corporation must be borne in mind. Most of the rules distinguish a non-stock corporation from a stock corporation. Ito, number 1, yung sa dividends. Walang dividends na receive yung mga members. Mga stockholders lang. Non-stock cannot engage in the business of, with the object of making profits. Ito, the right to vote. Pwede rin to. Applicable rin to sa stock corporation. So, basahin niya lang. Dami sila. So, non-stock corporation, through their AOI or bylaws, designate their governing board by any name other than the Board of Trustees. Trustees of non-stock corporation have duties similar to those of stock corporation. So, ganyan lang kaikli. Ito na yung last. Yan yung last provision or section ng Title 11. Maikli lang naman siya. Kasi nga, gaya na sabi natin, so starting pa lang, na yung mga non-stock corporation, yung mga provisions affecting governing stock corporations, applicable naman kasi pagdating sa non-stock. Di ba marami tayong na-mention doon. Applicable yun sa non-stock. Unless otherwise, may specific provisions, may specific sections under this title for non-stock corporation. So yan lang. So yan lang yung Title 11 natin. Napakaikli. So we will now proceed to Title 12. Okay. So, dito ngayon tayo sa Title 14. Title 14, Title 12. Kasi kanina, ang pinag-usapan natin is Title 11. So, itong Title 12, maikli rin to siya. Maikling discussion rin to. Siyempre, paspasan na tayo. Kaya 2 weeks na lang. End na ng klase natin. And pagka week after that, finals week na natin. So, ito, Title 12, which talks about close corporation. Di ba ang close corporation, ilang beses natin na-mention last time pa. And from our discussion sa mga previous videos natin, ang close corporation basically is a corporation kung saan hindi siya open corporation. It's not a joke kasi di ba ang open corporation, sa first lecture video pa lang natin, di ba, dinefine na natin kung anong open and kung anong close corporation. Ang open corporation, basically, ito ang isang corporation na kung saan kahit sinong tao o kahit sinong entity pwedeng mag-invest, bumili ng shares nito para maging stockholder. Yun ang open corporation. Ang isang closed corporation, limited lang ang kung sino yung pwedeng maging shareholder ng corporation na ito. So from that word alone, napansin nyo na ang isang closed corporation is basically a stock corporation. Pero hindi siya open, closed siya kasi limited lang yung number of persons na pwedeng mag-invest sa kanya. So ito, Section 95. So definition and applicability of title, which is closed corporation. So ang closed corporation, within the meaning of this code, is one whose articles of incorporation provides for the following. Yung una, all the corporations issued stock of all classes, exclusive of treasury shares, shall be held for record by not more than a specified number of persons, not exceeding 20. Not exceeding 20. So 20 lang yung pwedeng maging shareholder, stockholder ng isang closed corporation. Kasi as we have said, limited lang yung number na pwede maging stockholders ng isang closed corporation. Kaya nga siya close eh. As compared sa isang open corporation na pwede kahit marami. Hindi limited. And B, all the issued stocks of all classes shall be subject to one or more specified restrictions on transfer permitted by this title. So yung mga at least may yung mga issued stock per classes, at least one restrictions meron sila. a good example of that is pagdating sa transferability, i-offer muna sa mga existing stockholders before i-offer sa third persons, or such transfer must be approved by the remaining stockholders, di ba? And C, the corporation shall not list in any stock exchange or make any public offering of its stocks of class or of any class. So as you can see here, kasi di ba, pag pumasok ka sa sa stock exchange natin, gumawa ka ng public offering, mga IPO, initial public offering, you're basically inviting other entities para mag-invest sa corporation mo, sa corporation kung saan ka. So, basically that is an open corporation. By doing that, that's entailing to an open corporation. Hindi naman ganoon yung definition ng isang closed corporation kasi limited lang yung number of entities na pwede diyan. 20, not exceeding 20. So, kaya bawal yung mag-list ka, mag-offer ka ng stocks mo sa public because that entails na isa kang open corporation. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock when at least 2/3 of its voting stock is owned or controlled by another corporation, which is not a closed corporation within the meaning of this code. So from that alone. So as you can see, di ba? Sabi natin sa powers ng isang corporation, pwede sila mag-invest ng kanilang accumulated funds to another corporation. Hindi sila pwede mag-engage ng business not within their purpose. Pwede silang mag-invest in other entities, in other businesses, kahit na iba yung purpose nun. Basta invest lang ang gagawin nila. In this case, ang isang corporation pwede mag-invest sa isang closed corporation. Pero may binigay na provision itong batas natin in regards to that. Kapag 2/3 ang pagmamay-ari ng corporation na to sa isang closed corporation, yung ownership interest nito sa isang closed corporation is at least 2/3, and this corporation is not a closed corporation, meaning it is an open corporation, then yung closed corporation na ininvestan, yung investee na closed corporation, you cannot call them a closed corporation. Oo. So yun tandaan nyo, 2/3. A corporation investing in another corporation, kung saan itong corporation na to is open corporation, then yung ininvestan niya cannot be considered as a closed corporation. But tingnan, 2/3. Any corporation may be incorporated as a closed corporation except for these following types of businesses. Pag mining or oil companies, mga Petron, Shell, stock exchange, yung Philippine Stock Exchange natin, dati kasi dalawa yung stock exchange natin yung located sa Manila and yung located sa Makati. Pero as time passed by, nag-combine silang dalawa. So Philippine Stock Exchange na. Banks, insurance companies, public utilities, educational institutions, and corporations declared and other corporations that is declared to be vested with public interest in accordance with the provisions of this code. So the provisions of this title shall primarily be govern closed corporation. So itong title 12, ito yung mag-govern primarily for those corporations that is designated as closed corporation. Now, yung other titles in this code, pwede dito i-apply as a suppletory, except as otherwise provided under this title. So kapag may conflicting provisions in regards to the closed corporation, yung mananaig is under Title 12. Ito, definition of a closed corporation. Now, ito na-mention naman natin to dito A closed corporation has been defined as a corporation in which the stock is held in a few hands or in a few families. Kasi yan usually yung nature ng isang closed corporation. Magkakamag-anak, magkakaibigan, yung mga stockholders. Kaya sa kanila, limited lang yung pwedeng sumali sa kanila. So, kaya closed corporation, binigyan sila ng designation ng batas natin. Kasi yun usually yung nangyari na gusto nila within the family lang, within their circle lang, yung mamamahala, yung magmamayari over the corporation. Kasi sila lang yung pinagkakatiwalaan nila. And which stock is not at all or only rarely dealt in buying and selling. So, minsan-minsanan lang yung buy and sell ng stock kasi may mga restrictions rin yan eh. It has also been defined as one in which the directors and officers have the power to fill vacancies in their own number without allowing to the general body of stockholders any choice or votes in their election. Now, bakit kaya? Kasi 'di ba? Pag mag-elect sila, usually or generally, kailangan ng approval galing sa ng approval galing sa Pero dito kasi, ang meaning lang 'yan, since usually kokonti lang naman sila eh. Hindi pwede lumampas ng 20. So, most of the time, kung sino yung mga stockholders, without any election, sila na rin yung directors and officers ng closed corporation. Kasi nga, gaya na sabi natin, closed circle yan sila eh. Kung sino lang sa circle nila, yun lang ang pwedeng pumasok sa corporation. And with that, it entails na kung sino lang sa circle nila, yun ang pinagkakatiwalaan nila. Kaya, sa isang closed corporation, kung sino ang stockholders, siya na rin yung director, and sila na rin yung mga officers. Ganun lang. Now, peculiarity of a closed corporation. Now, the outstanding peculiarity, ibig sabihin pagka-special niya, of a closed corporation is the identity between the stock ownership and the active management. Kasi as we have said, in a closed corporation, all the outstanding stock, kung saan there being no publicly held securities of any other class, is owned by the persons who are active or members of their immediate families who are active in the management and conduct of the business. So, as we have said here, kung sino yung nagmamayari ng stock, usually sila na yung nagpapatakbo. It is essentially, unincorporated partnership. May similarities sa partnership. Ang kaibahan lang nga instead na mag-partnership sila, nag-corporation na lang sila. Bakit kaya? Malalaman nyo. In which the stockholders consider each other as partners but which the law treats them as a corporation kasi they incorporated instead of making a partnership. Gaya na sabi din, instead nag-partnership sila, nag-incorporate na lang sila ng corporation. Pero in essence, para din silang partnership kasi limited lang yung gusto nilang sumali. Kung sino lang sa circles nila, tapos less than 20 pa yung pwede. May mga partnership nga dyan na mas marami pa yung mas marami na more than 20 pa yung mga partners. Thus, stockholders in a closed corporation are very much like members in a partnership. They owe to one another the same duty of utmost good faith and diligence that partners owe one another. The strict duty applies particularly to controlling stockholders. So yan. Parang partnership, di ba? Ang isang closed corporation because of how close the circle is within the stockholders. Na sila lang, ito paulit-ulit kong sinasabi, di ba? Sila lang yung pinagkakatiwalaan kung sino lang sa circle nila. Now, meaning of term under the code. Now, within the meaning of this code, it is one whose articles of corporation provides for the following. Refers to the closed corporation. Kung saan itong closed corporation na to, all its issued stock, exclusive of treasury shares, kahit closed corporation, mayroong isang treasury shares, shall be held of record by not more than a specified number of persons not exceeding 20 as provided by the law. So yan. Pangalawa, lahat ng issued stock niya shall be subject to one or more restrictions on transfer permitted under this code. For example, even though sabi naman natin section 97, dyan na yan. And lastly, any of its stock shall not be listed sa stock exchange or offered to the public because doing so would entail na isa tong open corporation. Kasi di ba ang open corporation, kahit sino pwedeng pumasok, bumili ng shares. Generally. Di ba? Pero since hindi ganun tong corporation na to, so bawal yan. Na ito, all these three features, itong tatlo, must be present para yung isang corporation ma-classify as a closed corporation under the meaning of this code. Ito, gaya na sabi natin, 2/3 of the voting stock or voting rights sa isang corporation, kapag own ito ng another corporation na hindi close, ibig sabihin open corporation, then yung investee corporation, hindi matatratong closed corporation. Okay? So, tingnan nyo kung sino yung nagmamayari. Kasi, this open corporation basically controls that corporation kasi kapag 2/3 yung ownership sa stocks. So, kung ano yung nature ni parent na may control over the investee corporation. Parang yun na rin yung nature ng investee corporation. So kapag open corporation, 2/3 ang ownership sa isang corporation, then yung investee or corporation, you can make trato of that, or treat that as an open corporation. Pero pag less than 2/3, okay, goods pa. Corporations which are vested with public interest, such as those mentioned dito, hindi sila pwedeng incorporate sa closed corporation. Bawal. Vested with public interest sila eh. No? Bank, insurance, public utilities. Now, applicable provisions as we have said, Title 12, yung mamamahala sa closed corporation. Yung other titles under the Revised Corporation Code, supplementary lang sila. Pag may inconsistency, then Title 12 yung mananaig. Now, why do we need special rules for closed corporation? Now, in a closed corporation kasi, we are dealing essentially with an incorporated partnership. Ilang beses natin na-mention yan. Indeed, ang closed corporation has also been described as a corporation de jure and a partnership de facto. Corporation de jure, kasi yung essence niya basically a partnership de facto, kasi instead of forming a partnership, they chose to form a corporation. Parang ganun yung niyan. It may in fact be that the business began as a proprietorship or a partnership and then the parties decided to incorporate for tax reason to insulate themselves from liability. So ito yung mga reasons sinabi natin kung bakit pinipili ng mga tao na instead ng partnership, instead ng sole prop, corporation na lang. To insulate themselves from liability, to obtain outside capital, or to meet the problems of continuity and transferability which arise at the death of or retirement of one of the members. So basically, itong mga sinabi nating reasons, basically yan yung mga advantage, di ba, ng isang corporation. Tax reason. Baka nakakuha sila 25% na lang ata tax natin ngayon for corporate tax, if you remember correctly. Tapos, ano pa dito? Kasi pagdating sa partnership, bayad din ka rin tax. So, kung anong bibigay na income, gano'n rin. Insulate themselves from liability, di ba? Limited liability lang, corporation. Generally, as long as walang bad faith or fraud that was performed by the directors, members, or mga stockholders, officers, para walang doctrine of piercing the corporate veil, di ba? Veil, di ba? So, yun, limited liability generally. Obtain outside capital, kasi sa partnership mahirap eh. Kailangan ka pa pero pang gano'n rin ang idea eh. Papasok ka ng partnership sa closed corporation. Mahirap rin yung pasukan dyan. Or to meet the problems, to meet the problems of continuity and transferability. Kasi sa partnership, di ba, sigaya na sabi natin, once namatay, nag-retire yung isang or any other reason, yung isang partner, dissolve agad. Tapos, pag-usapan pa nila kung i-continue. Sa corporation, kapag namatay yung isang stockholder, it does not necessarily mean na madi-dissolve yung corporation. Hindi. Pwede niya lang i-transfer yung ownership interest niya. Madalian. Wala nang pahirapan pa. A closed corporation then has special needs and problems different from those of a widely held corporation. Kasi yung mga widely held corporation, lalo na yung mga vested with public interest, mas stringent yung government pagdating sa kanila. Pero of course, since as you can see, binigyan ng special title, ng separate title ang closed corporation, binigyan kasi tawag dito, para yung needs in order to regulate this closed corporation due to how close they are, para ma-prevent kung ano mang masamang mangyari. Kasi as you can see, close corporation sila, magkakakilala, magkakamag-anak, magkakaibigan lang yung mga may-ari. So baka may gawin silang scheme para magloko. And with the fact na pinagkakatiwalaan nila yung isa't isa, posible yung mangyari. So, in order to prevent any eventualities na will cause problems in regards to close corporation or in regard to this type of corporation, even our previous corporation code, binigyan na ng separate title to govern, specifically govern this peculiar type of corporation. So, Articles of Incorporation, Section 96. Anong nilalaman nito? May special ba dito? As compared sa isang ordinaryong open stock corporation? Malalaman natin. The Articles of Incorporation of a closed corporation may provide for us this following. Classification of shares or rights, the qualification for owning or holding the same. May qualification pa. Hindi lang basta-basta makahawak o makakuha ng shares or rights sa isang closed corporation. Kailangan mo pa ng qualification. Di ba? And restrictions on their transfer. Usually, ang mga restriction dyan is pag ita-transfer mo, dapat ibenta mo muna kung sa mga existing stockholders and subject to the provisions of the following section. A classification of directors. Classification of directors. Yan. 'Di ba? Sa natin, stock corporations natin, sa open corporations natin, 'di ba? Open stock corporations sa mga previous discussion natin, walang classification ng directors. Directors lang agad. Dito pagdating sa closed corporation, may classification of directors tayo into one or more classes. So, each of whom may be voted for and selected solely by a particular class of stock. And a greater quorum of voting requirements in meetings of stockholders or directors than those provided in this code. So, pwede sila mag-provide nan. Now, the Articles of Incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors. Oo. Ilang beses natin na-mention yan. So long as this provision continues in effect, no meeting of the stockholders need to be called to elect directors. Provided, however, na the stockholders of the corporation shall be deemed to be the directors for the purpose of applying the provisions of this corporation code. Unless the context clearly requires otherwise, provided further na the stockholders of this corporation shall be subject to all liabilities of directors. The Articles of Incorporation may likewise provide that all officers or employees or that specified officers or employees shall be elected or appointed by the stockholders themselves instead na dumaan pa sa board of directors. So as you can see here, haba-haba ng basically sinasabi niyan, yung stockholders, pwede sila na mismo yung directors basta provided. And sila na rin yung sila na rin yung magpe-perform ng acts ng isang director. Ngayon, permissible provisions in Articles of Incorporation. The matters mentioned in Section 96 are allowed to be provided sa Articles of Incorporation ng isang closed corporation. Ito sila. Una, yung classification of directors into one or more classes. Now, as provided sa illustration number 2 in paragraph 1, is where the Articles of Incorporation provides for two classes of stock, A and B. Class A, Class B stocks. Now, allocating a number of directors for each class and the holders of each class would be elected to the board of directors solely by the holders of the same class, regardless of the numbers of shares in each. But the members of the board of directors cannot be divided into groups with each group having different term of office. It is not clear, etc. The classification is not allowed in ordinary or widely held corporations, sa mga open corporation. Yung classification of directors, peculiar lang siya, special lang siya pagdating sa closed corporation. Anong meaning nito, sir? Ibig sabihin nito, sample lang to, may class A tayo, may class B tayo na shares. And itong class B and class A na shares, meron din tayong tinatawag na class A na director and class B na director. Kasi under this corporation code, under this title, under this provision sa closed corporation, pwede kang mag-classify ng 2 or more directors. Yung pag-classify mo ng 2 or more directors, manggagaling sa kung ano mang shares sa kanila. So, itong Class A share, sila lang yung pwede mag-elect sa Class A directors. Yung Class B share, sila lang yung pwedeng mag-elect sa Class B director. Hindi yan pwede mag-overlap. Pero pag naging board of directors na sila, Pag naging board of directors na sila, walang division. Board of directors sila as it is. Nagkakaroon lang ng classes, depende sa pag-elect sa kanila. Class A, elect lang sa isang Class A director, manggagaling sa kanila. So yung Class A director na yan must be a Class A shareholder rin. Class B director, Class B shares, mag-elect sila among them, the Class B shareholders, kung sino sa kanila ang magiging Class B directors. Na ito sila, magiging grupo na yan sila. Lag mo itong pen na to. Magiging sila, as a director na sila. Now, pag director na sila, walang division. Basically, nagkakaroon na ng classification of directors when it comes to their election. Pero pag directors na sila, they cannot be divided into groups. With each group they having different terms of office. Yan na. Peculiar yan pagdating sa closed corporation. Kasi 'di ba, sa open corporation, sa open stock corporation, kahit na anong classes of shareholders ka pa, when you will elect a director, you will elect them as a whole. Walang classification. Walang Class A director, walang Class B director. Walang klase ng wala na. Diretso agad director as it is. Pero pagdating sa closed corporation, kapag Class A shares ka, you can only elect Class A director among you. Pag Class B shareholders ka, you can only elect Class B director from among you. Pero pag na-elect na sila, pag na-elect na sila as directors, wala nang grupo-grupo. Wala nang divided into groups. As one whole na sila. Pag na-elect na sila. Quorum and voting requirements. So as we have said, guys, sabi ito, etc. May closed corporation may provide for a quorum and voting requirements in a meeting of stockholders greater than those provided in the corporation code. Now, technically, hindi to peculiar, di ba? Kasi kahit yung open corporations, pwede din sila mag-provide ng higher quorum. Diba? Unless otherwise provided sa bylaws o sa articles of incorporation, naka-mention naman doon sa provisions. Pero yung minimum na 2/3 or majority, hindi pwede yung galawin. They can only provide higher. Management of the corporation by the stockholders. As we have said, ilang beses natin nasabi to. Where the articles of incorporation provided the business of the corporation shall be managed by the stockholders themselves rather by the board of directors, then the stockholders shall be deemed to be the directors with all the liabilities imposed by the code on directors. So, in an ordinary stock corporation, the management or conduct of business affairs thereof is entrusted to a board of directors and cannot be turned over to stockholders except for a few specified matters concerning its internal affairs. Diba? Yung sa mga discussion natin. Kaya, ano yung reason? Bakit, diba? Ulitin na natin, recap lang. Ano yung reason? Bakit kailangan ng board of directors? Kasi yung board of directors na yun, compact size sila maliit lang sila. Efficient yung pagpapatakbo ng corporation kapag a small group of people lang. Kasi pag marami yan, yung mga stockholders yan ang paggalawin mo, magulo yan. Convoluted yan Magulo, anarchy yan. So, para maging efficient, ka na ng board of directors sa compact size of group of people para magpatakbo to govern the corporation. Yun yung purpose kaya may board of directors tayo. However, pagdating sa isang closed corporation, yung problema na maraming stockholders, non-existent kasi ang limited number lang is 20. So in that case, yung purpose mo na magpa-elect ng board of directors, parang nadidiminish, di ba? Kasi kukunti lang yung stockholders, so hindi magulo. If ever man, ibigay mo sa stockholders yung pamamahala sa isang corporation. So since this problem is non-existing sa isang closed corporation, sabi ng batas natin, sure, pagdating sa closed corporation, as long as provided sa kanilang articles of incorporation, yung stockholders, pwede sila na mismo yung mag-govern sa corporation. Hindi na kailangan mag-elect pa sa board of directors. And with that, sabi ng batas natin, in that case, yung ating code, corporation code, will treat these stockholders as directors. Yun. That is a very peculiar. Isa yun sa mga special pagdating sa isang closed corporation. No need na ng board of directors, stockholders na mismo diretso ang mamamahala. Ito naman, election or appointment of officers directly by stockholders. The articles may likewise provide that all or certain specified officers or employees shall be elected or appointed directly by the stockholders instead of the board. Obviously, in the ordinary stock corporation, corporate officers are elected by a majority of all the members of the board of directors. So, yun. Di ba? Sa closed corporation, since yung stockholders na mismo yung namamahala, di sila na mismo yung pipili kung sino yung officers ng corporation. Stockholders in a closed corporation are very much like members in a partnership. They owe to one another the same duty of utmost good faith and diligence that partners owe one another. This strict duty applies particularly to controlling stockholders. So yan, closed corporation, very peculiar as compared to ordinary open stock corporation. Now let's go to section 97. Section 97 provides for the validity of restrictions on transfer of share. Now, balikan natin, di ba sabi dito, isa sa mga distinguishing factors, distinguishing qualification ng isang closed corporation is yung, sana dito yun? Sana yun? Sa section 95 pala yun. Is yung, sana yun? Ito, letter B. All the issued stock of all classes shall be subject to one or more specified restrictions in regards to their transfer. So, ibig sabihin, when it comes to the transfer of the shares of the stocks of the closed corporation, dapat at least may isang restriction in regards to that. And with that, dito tayo kay section 97 which provide for that matter. The validity of restriction on transfer of shares. Restrictions on the right to transfer shares must appear in the articles of incorporation. So dapat, for its validity, dapat nasa articles of incorporation siya. In the bylaws as well as in the certificate of stock. Otherwise, kapag wala yan, the same shall not be binding to any purchaser in good faith. Tandaan nyo, purchaser in good faith. Kasi kapag in bad faith yan, di binding yan sa kanya. Bakit? Kasi may knowledge na siya sa restriction. So since may knowledge na siya sa restriction, he cannot claim ignorance as a valid defense. So it will be enforceable to him. But if the purchaser is in a good faith, then the purchaser can claim ignorance as a valid defense. Sabi niya, hindi ko rin alam eh. Hindi naman kasi stated sa AOI nung binasa ko. Hindi naman kasi stated sa bylaws nung binasa ko. Hindi naman stated sa certificate of stock nung binasa ko. Yung restriction. So with that, since in good faith ka, it is a valid defense. Yung ignorance mo. So, said restrictions shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable term, conditions, or period stated if upon the expiration of said period, the existing stockholder or the corporation fails to exercise the option to purchase those stocks, then the transferring stockholder may sell their shares to any third persons. So ito, restriction on shares or the transfer of shares. Now take note, when we talk about transfer of shares, it does not necessarily mean na yung binibenta. It does not necessarily mean na such term is limited only to those shares na binibenta. Pwede rin yan sa donation, mag-donate ka ng shares, o yung mga shares na kapag namatay ka, ipapasa mo as inheritance. Oo, hindi lang limited sa selling for value. Pwede rin applicable yan sa mga donation, sa inheritance, damay yan. Now, one of the distinguishing characteristics ng isang closed corporation is yung mga stocks nito, yung mga shares nito, at least one shall be subject to one or more specified restrictions permitted under Title 12. Anong mga sample niyan? Depende. Malalaman nyo. Section 97 imposes two conditions for the validity of restriction on the right to transfer shares, namely, So kapag hindi yan hindi na satisfy yung dalawang condition na yan, edi hindi valid yung restriction. Hindi mo siya pwedeng gawin as an argument. Kasi sabihin niya di yung follow yung dalawang conditions provided by Section 97. So yung restrictions nyo, wala yan. Matatalo yung kaso mo. Pag hindi mo na satisfy itong dalawang conditions na to sa pag-validity, sa pagiging valid ng restrictions mo. So ano itong dalawang to? Provided naman dito. Yung una is yung such restriction must appear sa Articles of Incorporation, sa bylaws, pati na rin sa certificate of stock na ibibigay mo sa shareholder. Otherwise, they shall not be binding to any purchaser thereof in good faith. Kita nyo dito? Sir, what if sir, ganito, Articles of Incorporation lang or sa bylaws lang nalagay, pero pagdating sa certificate of stock, wala siya. Hindi nakalagay. So, paano yan sir? Depende. Let's say, itong taong to, binasa yung Articles of Incorporation, binasa yung bylaws, nakita niya din restriction. Pero pagdating sa certificate of stock, wala din yung restriction. So, ano masasabi niya doon? He cannot claim na good faith siya. Bakit? Na-purchaser siya at good faith. Bakit? Kasi alam niya naman dito aware siya. He cannot claim a valid defense of ignorance kasi alam niya nabasa niya sa Articles of Incorporation, nabasa niya sa bylaws na nandun yung restriction. So, hindi niya pwede maklaim yung valid defense of ignorance kasi kahit nawalan sa certificate of stock, aware siya. Alam niya yung restriction. So, he cannot claim a valid defense of ignorance. Pero pag ikaw, gaya na sabi natin kanina, hindi mo binasa yung Articles of Incorporation and bylaws. Pero medyo delikado yan kasi as a investor, kailangan alam mo kung ano yung pinapasukan mo. So, babasahin mo yan. Paparequire siya basahin. So, let's say, wala sa Articles of Incorporation, wala sa bylaws, wala sa certificate of stock. Pero aware na basically parang aware siya sa restrictions na pamilya lang pwede, mga kaibigan lang within the circle. So, he can still claim a valid defense of ignorance na hindi niya alam na good faith siya kasi aware siya So, yun lang yung pivotal factor doon. Kung aware yung purchaser sa restrictions, kahit na saan pa yung nakalagay o hindi nakalagay, he cannot claim a valid defense. Bad faith siya. Pero pag good faith yan, wala siyang alam Valid defense of ignorance. So, wala. Dehado ang restrictions mo. So, yun lang. So, yung pivotal factor doon, yung deciding factor is kung aware yung purchaser. They shall not be binding on any purchaser thereof in good faith. Pangalawang condition, they shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholders with such reasonable terms or conditions or period stated therein. Like for example, kung i-offer mo yung shares mo for 10 pesos per share, dapat 10 pesos per share rin yung pag-offer mo sa existing stockholders or sa corporation kapag ibebenta mo na, ita-transfer mo na. Hindi ka pwede maging mas onerous na pagdating sa sa existing stockholders or sa corporation, i-offer mo siya as 10. Pero pagdating sa outside parties, offer mo sa kanya as 9 pesos per share. Hindi pwede. Dapat, it shall not be more onerous. Dapat pantay lang sila. Kung 10 pesos sa outside parties, then 10 pesos rin yung pag-offer mo pagdating sa existing stockholders or sa corporation. Okay? Now, thus, a restriction fixing the purchase price, very much below the fair market value of the shares may be invalid. Okay. Also, invalid is a prohibition against transfer of stock without prior consent of the board of directors or of the other stockholders. Saan tayo yun? Also, prohibition against wait lang. So, need for stock transfer restrictions in closed corporation. Ayun, mahalagang ano. Tiyan nyo rin dito, invalid din kapag yung isa sa mga restrictions mo, isa sa mga prohibitions mo is yung kailangan mo pa ng prior consent ng board of directors and the other stockholders para magbenta ng iyong shares. Na ay, ayaw namin ibenta ang shares na yan. Gusto mo namin sa'yo lang. Bawal yung ganun. Hindi mo kailangan ng consent nila. Kung gusto mo ibenta yan, goods, benta mo. Ang restrictions na binibigay sa'yo dito, usually, is sa kanila mo muna una i-offer. Pag hindi nila nabili yan, di pwede mo na ibenta sa ibang tao yan, sa outside parties. Hindi kanila pwedeng pagbawalan na ibenta yan. Kasi they basically, basically, ang ginagawa nila is, not necessarily illegal detention, but rather, pinipilit ka nila sa bagay na ayaw mo. Pinipilit ka nilang manatili kahit na ayaw mo na, kahit gusto mo nang umalis. Sabi ng batas natin, bawal yon. Hindi mo kailangan ng consent nila. Kung gusto mo umalis ka. Benta mo ang shares mo. Ang prohibition lang sa'yo, ang restriction lang sa'yo, if ever stated naman, ibenta mo muna sa kanila. Sa kanila mo muna una i-offer. Sa existing stockholders or sa corporation. Kapag hindi nila tinanggap, ayaw nilang bilhin, edi sorry sila, benta mo sa ibang parties. Kasalanan nila eh. Hindi nila binili sa'yo. So, need for stock transfer restriction in closed corporation. So, bakit kailangan ng restriction? Diba? Isa yan sa mga peculiar characteristic ng isang closed corporation na kailangan may restriction sa transfer of stock. Ito, prevent changes in control of corporation. Excuse me po. As noted earlier, kapatid, one of the major objectives of the shareholders ng isang closed corporation is that it remain to be closed. Meaning, kung sino lang yung sa circle nila, yun lang yung mamamahala. Yun lang yung magiging kasama sa kanilang corporation. They choose it as it is, kung sino lang yung gusto nila. I.e., to choose new partners on the death or retirement of the present shareholder participants. So, basically, tawag dito, delectus personae, delectus personae, diba? If you can still remember our discussion sa partnership, ano yung delectus personae? Delectus personae basically means that you choose the persons who you want to be associated with. Applicable rin dito pagdating sa, medyo applicable yan dito pagdating sa closed corporation. Kasi yun yung objective nila eh. Gusto lang nila piliin sino yung pwede. Na kakilala nila, kaibigan nila, kapamilya nila. Although restrictions on the transfer of share are occasionally adopted for other reason, the usual purpose of such restriction is to prevent changes in control of the corporation which may otherwise result from the transfer of voting shares. Like for example, yung gustong umalis sa closed corporation, may 51% ownership sa stocks. Gusto niya umalis eh. Ayaw niya na ng ganun klaseng buhay. So, since yung may ownership, he is restricted na i-offer muna yan sa remaining, sa existing stockholders or sa corporation itself. Para to prevent a change in the control of the corporation. Kasi pag ibebenta niya sa third parties, sa hindi related sa mga existing stockholders, hindi man nila kakilala, third parties, edi yung control ng corporation basically mapupunta na sa outside parties. Di ba? So, prevent changes in control. And ito, maintain delectus personae. Pagdating sa mga widely held corporations, mga open corporations natin, na kailangan ng centralized management distinguished from the owners, which in a closed corporation may not needed be or desired kasi kung sino yung mga nagmamanage, sino yung nagpapatakbo, sila na rin yung shareholders. With no clear differentiation, separating one capacity from the other. So the idea that they must act as a fiduciary directors, tanda natin, ano meaning ng fiduciary? It is a relationship based on trust. Fiduciary directors, so pinagkatiwalaan nila yung directors nila for the benefit of themselves as passive beneficial owners will strike them as a legalistic nonsense. So ito, prevent changes in control and maintain delectus personae. Delectus personae, ano yan? You choose the persons you want to be associated with. You choose the persons who you want to be associated with, which is very applicable pagdating sa closed corporation. Kaya limited lang yung pwede pumasok. Now, what are the effects? Dito, Section 98. What are the effects of the issuance or transfer of stock in breach of qualifying conditions? So, ano mangyayari? May mga certain restrictions. May mga conditions tayo when it comes to the transfer of stocks. What if na-violate yun? Anong magiging effect? Section 98 provides for that. Ang unang effect daw na pwede, if a stock of a closed corporation is issued or transferred to any person na hindi eligible to be a holder thereof under any provisions of the Articles of Incorporation. What do you mean, sir, eligible? Diba sabi natin dito, saan yun? Saan dito yun? Nilagay natin yung, ito, a classification of shares of rights, the qualification for owning or holding the same, and the restrictions on their transfer subject to the provisions of the following section. Meaning yan, pwede mong lagyan ng qualifications kung sino pwede maging stockholder ng corporation nyo. Ng closed corporation na yan. Pwede nyo lagyan ng qualification. Like for example, ilagay nyo, dapat, let's say yung corporation nyo is situated, yung closed corporation nyo situated sa Zamboanga City. So, isa sa mga qualification nyo is that, na para maging stockholder, is that dapat residente ng Zamboanga City. So yan, qualification yan. Another qualification na pwedeng ilagay nyo na, for example, tawag dito, dapat descendant siya ng original incorporators ng closed corporation. Ibig sabihin, dapat kamag-anak, kaapu-apuhan ng mga original incorporation o mga anak nila, pamangkin nila o parang gano'n, di ba? Para within the family lang. Or lagay nyo sa qualification, dapat may college degree yung stockholder. Di ba? Pwede sa maglagay ng qualification dyan as long as hindi labag sa batas. So yan, in that case. So dito sabi dito, if a stock of a closed corporation is issued or transferred to any person who is not eligible to be as holder thereof under any of the provisions of the Articles of Incorporation. Like for example, sa example natin, isa sa mga qualification, residente ng Zamboanga City. Pero residente pala siya ng Pagadian. O yun, hindi siya qualified maging holder. Pag ganun yung scenario, so dito sa natin, a holder thereof under any provisions of the Articles of Incorporation, and if the certificate for such stock conspicuously. Ano yun ang conspicuously, sir? Basically, parang klarong-klaro na nakalagay sa stock certificate yung qualifications na dapat taga Zamboanga City. Tapos alam niyang taga residente sa ng Pagadian. Yan, meaning ng conspicuously dapat stand out, klarong-klaro, very visible sa certificate of stock. So hindi siya pwede tago, dapat very visible siya. So be careful pag magano kayo ng stock corporation, tingnan nyo, dapat very visible. And if the certificate for such stock conspicuously shows the qualification of the persons entitled to be holders of record thereof, then such person, gaya na sabi natin, kailangan resident ng Zamboanga City pero taga-Pagadian siya, then such person is conclusively presumed to have notice of the fact of the ineligibility to be a stockholder. Meaning, alam siya, aware niya. Alam niya na kailangan residente ng Zamboanga City yung stockholder. Nakita niya, nabasa niya May requirements tayo dito So with that, it is conclusively presumed to have notice of the fact of the ineligibility of the stockholder. So, certificate of stock conspicuously dapat very visible. Pangalawa, if yung articles of incorporation of a closed corporation states the number of person not exceeding 20 who are entitled to be stockholders of record, and if the certificate for such stock conspicuously states as number. Sabihin ng stock certificate, 20 out of 20, there are already 20 stockholders in this closed corporation. Conspicuously, very visible, stated sa stock certificate. And the issuance or transfer of stock to any person would cause the stock to be held by more than such number of persons. So, kapag i-issue mo pa yun sa kanya, maging 21 na. O, di ba? Klarong-klaro nakalagay sa stock. Very visible, conspicuously. 20 na yung stockholders. Then, kapag mag-i-issue ka pa ng additional stock sa kanya, then magiging 21 na. Then, ang presumption dyan, the person to whom such stock is issued or transferred is conclusively presumed to have notice of this fact. Na, alam niya na eh. Na, presume, aware siya na kapag i-issue sa kanya yung stock na yun, lalampas na sa maximum 20. Magiging 21 na. So yan naman, presumption yan. Dito, presumption, kapag nakalagay yung qualification, very visible sa stock certificate, tapos alam niya na hindi siya qualified, then presume he has notice na hindi siya qualified. Same rin dito. He has notice na hindi siya qualified. Dito tayo sa letter C, if a stock certificate of a closed corporation conspicuously shows a restriction or transfer of the corporation stock and the transferee acquires the stock in violation of such restriction, then the transfer is conclusively presumed to have notice of the fact that the stock was acquired in violation of such restriction. Like for example, alam niya na isa sa mga restrictions is to offer the stocks first to the existing stockholders or to the corporation itself. Alam niya na restriction yun. Pero sa kanya una in-offer ni stockholder. So with that fact, it is presumed na may notice siya na na-violate yung restriction na yun. Na dapat i-offer muna sa existing stockholders or sa corporation. Now in that case, anong mangyayari? Anong mangyayari sa tatlong to? Anong mga next sections natin dyan? Now whenever a person to whom stock of a closed corporation has been issued or transferred has or is conclusively presumed under this section to have notice of itong tatlong to, the person's ineligibility to be a stockholder of the corporation, that the transfer of stock would cause the corporation to be held by more than the number of persons permitted under each article of incorporation. So kahit nasabihin na 15 lang yung maximum sa articles of incorporation, kapag i-issue sa kanya magiging 16 na, violation rin yun. Or that the transfer violates a restriction of transfer stock and the corporation may at its option, anong pwedeng gawin ng corporation? Dito provided. At its option, may refuse to register the transfer in the name of the transferee. So kapag nag-violate to dito, na may notice si transferee, si corporation, the corporation can refuse to register the transfer. Pagbawalan niya na maging official stockholder yan. Sabi niya, hindi mo nga finalo yung proper qualification namin. Violate mo nga yung mga conditions namin. Alam mong hindi ka eligible. Bakit ka namin papapasukin dito? Yun ang sabi ni corporation. The corporation can refuse to register. However, dito tayo kay letter E. The provisions of section D shall not be applicable if the transfer of stock, even though na-violate niya yung ABC, na-violate niya itong tatlo, has been consented to by all the stockholders of the closed corporation, or if the closed corporation has amended its articles of incorporation in accordance with this title. Yun, kapag may consent or kapag may amendment in regards to that, okay, goods. Pwede siyang ma-register as an owner of that stock. Like for example, sa articles of incorporation nakalagay lang na 15 yung pwede maging stockholder. Ngayon, papasok to siya. So pagpapasok siya, magiging 16 na. So with that, pag nagkaroon ng amendments para pataasin yung limitation, gawin nilang 16 o gagawin nilang maximum 20, goods na. Pwede na siyang ma-register. Gaya na sabi natin kanina, the term transfer as used in this section is not limited to a transfer for value kasi pwede rin dyan yung donations or inheritance, goods yun. Now that the provisions of this section shall not impair any right which the transferee may have to either rescind the transfer or to recover the stock under any express or implied warranty. Like for example, niloko siya ni transferor na yung stock na binibenta niya sa kanya kay transferee na pwede niyo yung bilhin na walang problema doon, na mare-register lang yun agad-agad ng corporation, pero yun pala hindi. Binigyan siya ng assurance, pero yun pala hindi and hindi. So pwede niyang i-cancel, i-rescind yung kanilang kasunduan and i-recover yung magkano yung nabayad niya. So ito, same lang yan. Ito agreements of the stockholder, basahin niyo na lang, to agreements nila, etc., etc., etc. Basically ito lang yan. Section 99, consider as valid between the parties the agreements mentioned when executed by the stockholders of a corporation. Kasi pwede sila magkaroon ng agreements duly signed and executed before the formation and organization ng closed corporation. And such agreement, kapag it is by their intent, will extend, pwedeng ma-continue kahit na established na yung corporation, yung closed corporation. It makes clear that even if the effect of a provision in any written agreement relating to any phase of the corporate affairs is to make the parties partners among themselves, the same shall not be violated, etc., etc. So yan, talks about basically the validity of agreements between the stockholders. So let's go to section 100. So naka 100 na tayo sa sections natin sa Revised Corporation Code of the Philippines. Yay! 100! Sana ganyan din scores nyo sa final exam. So sabi dito section 100, when a board meeting is unnecessary or improperly held. So kailan daw na hindi na kailangan ng board meeting? Kailan daw na ang isang board meeting improperly held? Ano ang mangyayari? Section 100 provides for that. Unless the bylaws provide otherwise, any action taken by the directors of a closed corporation without a meeting called properly and with due notice shall nevertheless be deemed valid. So kahit na wala yung proper procedural matters when it comes to acting in behalf of the corporation, pwede pa rin maging valid yun, yung action na yun, kapag present ito either sa apat na to. So pwede pa rin maging valid kasi ni-ratify. Paano? Ito, una, magiging valid yan kahit na hindi na-follow yung procedural matters, procedural requirements, kapag before or after such action is taken, a written consent thereto is signed by all the directors. So kahit na hindi na properly followed yung procedural matters, procedural requirements, merong consent ng lahat ng directors na sabi, okay, goods lang yan. Kasi kahit nandyan man kami, doon, if ever man at first na-decide yan, papayag pa rin kami at the first place. So, goods pa rin. Pangalawa, so either, di ba? Tamang wording na gamit dito, or term. Or. So, either dyan ang maging present. Ibig sabihin, valid pa rin. So, sa letter B, another instance na pwede maging valid yung action taken by the board of directors without a meeting called properly, kung saan yung procedural matters was not properly followed, is this, all the stockholders have actual or implied knowledge of the action and make the prompt objection in writing. So, sa kanila, parang sa board of directors, implied list for them, goods pa rin yan. Payag kami. Pangatlo, the directors are accustomed, the directors are accustomed to take informal action with the express or implied acquiescence of all these stockholders. So, basically, goods pa rin. Kapag accustomed sila, parang that is how their company operates. That is how their corporation operates. Na as long as it is good for the corporation, goods na rin yan sa mga stockholders or sa other directors. And lastly, all the directors have expressed or implied knowledge of the action in question and none of them makes a prompt objection in writing. So, as you can see dito sa apat, basically, di ba, parang whether kapag nalaman nila, then for them, goods pa rin. Hindi sila kumukontra. Di expressly man or impliedly, okay rin sa kanila. So yung action na yun taken by the directors without meeting called properly for such matter, ibig sabihin yung procedural requirements hindi na follow, magiging valid pa rin yung action na yun. Kasi basically nagkaroon ng consent or ratification coming from the stakeholders. Sino-sinong stakeholders? Yung directors and stockholders. An action within the corporate powers taken at a meeting held without proper call or notice is deemed ratified by a director who failed to attend, unless after having knowledge thereof, the director promptly files his written objection with the secretary of the corporation. So pag ganun yung nangyari, ibig sabihin, hindi siya pumunta sa meeting eh. On a meeting held without proper call or notice, tapos yung director deemed ratified kapag hindi siya nakapunta. Pero after having knowledge, pwede siya magreklamo. Kaya simple lang, di ba? Kahit improperly held, basta may consent ang lahat, goods pa rin. So, simple lang. Ito. Now, preemptive right. Now, preemptive right, anong meaning yan? Diba? Discuss natin yan sa open corporations, sa stock corporations. Na the preemptive right, pagdating sa mga open corporations, sa mga widely control, na kapag magi-issue ng stocks yung corporation, i-offer muna sa existing stockholders before i-offer sa outside parties. Diba? Yun yung preemptive right na napag-usapan natin. Na pag magi-issue ng stock yung corporation, whether new stock man yan from its new issuance man yan or galing sa treasury shares niya. Basta magi-issue ng stock si corporation, i-offer muna yan sa existing stockholders. Why? Para these existing stockholders will remain there, mananatili yung kanilang control, yung ownership interest sa corporation. Pwede lang yan mabenta ng corporation, pwede lang yan mag-issue ang corporation to the outside parties kapag hindi binili ng mga existing stockholders yung bagong issuance na yun. Diba? Yun yung preemptive right na napag-usapan natin. Ngayon dito sa sa closed corporation, meron din tayong preemptive right. Applicable rin dito. Pero pagdating dito sa closed corporation, mas stricto. Mas wide yung coverage ng preemptive right na to. Sabi dito, Section 101, preemptive right in closed corporations. The preemptive right of stockholders in closed corporations shall extend to all stock. Hindi lang sa mga new issuance. Hindi lang sa mga reissuance, lahat ng stocks. Including the issuance of treasury shares, whether for money, property or personal services or in payment of corporate debts, unless the articles of incorporation provides otherwise. So in a closed corporation, the preemptive right of stockholders, Section 38, extends to all stocks to be issued, whether common or preferred, voting man yan or non-voting, newly authorized shares or yung newly issued balance of originally authorized shares including treasury shares. Whether the consideration for the issuance of the stock is cash man yan, cash, money, or personal services or in payment of corporate debts, and whether or not its denial will affect their relative interest or positions in the corporation. So damay lahat ng stock pagdating sa closed corporation. In other words, the right of preemption is a matter of absolute right on the part of the stockholders, except only when limited or curtailed by the articles of incorporation. So, unless otherwise provided, unless na kontra sa may limitations provide sa articles of incorporation, then applicable yan. This is of vital importance. Bakit? Kasi in a closely held corporation, to keep the association intact and prevent the shifting of control, delictus personae and protection of ownership interests from one faction to another or to unwelcome outsiders, and thus avoid deadlocks in the management of the corporation. So basically, same sa reason bakit na-form yung or bakit may restriction sa transfer of shares, di ba? Protection of ownership interests and delictus personae. You choose the person you want to be associated with. The other exceptions provided in Section 38 are not applicable. Now, gaya na sabi natin, in a widely held corporation, the preemptive right extends only to new shares out of an increase of the capital stock. So yan lang yung preemptive right na napag-usapan natin. Only to new only to new issues of shares out of an increase of the capital stock. O yan lang. Sa widely held corporation, napaka-limited. Yan lang. Pagdating sa preemptive right ng closed corporation, ang dami-dami. Oh. Ito naman, Section 102. Now, Section 102 talks about the amendments sa Articles of Incorporation. So, that is express power, di ba? Provided sa mga corporation natin na they can amend their Articles of Incorporation. Meron din dito sa closed corporation. Any amendment to the Articles of Incorporation which seeks to delete or remove any provision required by this title or to reduce a quorum or voting requirement stated in the said article of incorporation shall require the affirmative vote of at least two-thirds din of the outstanding capital stock. Take note, affirmative vote. Hindi lang yung written assent. Whether with or without voting rights. Kasi, di ba? May mga instances na lahat kailangan magboto kahit walang voting rights. And yung isa sa mga instances na yun is amendment sa Articles of Incorporation, di ba? Or such greater proportions of shares as may be specifically provided sa Articles of Incorporation for amending, deleting, or removing any of the aforesaid provisions at the meeting duly called for the purpose. So as we have said, any amendment sa Articles of Incorporation must comply with the requirements prescribed by the above provision. The amendment must be approved at the stockholders meeting duly called for the purpose. Kasi ang sabi dito, voting. Hindi lang pwede written assent. Mere written assent of the stockholders which is allowed under Section 15 is insufficient. Dito kailangan ng meeting para doon sila magboto. The other provisions of Section 15 applies. Now, note that even those without rights are entitled to vote because this is a major change sa corporation. The effect of the amendment is to terminate the status of the corporation as a closed corporation. Yun. Kasi ang sabi dito, bakit sir? Tiyan nyo, any amendment to the Articles of Incorporation which seeks to delete or remove any provisions required by this title. Di ba? Required by this title. Ibig sabihin, kapag tatanggalin mo yan, yung mga required sections for a closed corporation, kapag tatanggalin mo yan sa iyong Articles of Incorporation, anong pinapertain nun? It means lang na hindi na closed corporation yung classification ng corporation na yan. Kasi tinanggal nyo, delete or remove yung mga provisions required by the Title 12 for closed corporation. So kapag tinanggal nyo yan, mga provisions na yan na required, ibig sabihin you are now reclassifying that corporation from a closed corporation to an open corporation because you are now saying with your amendment na hindi na kayo magpa-follow ng provisions under a closed corporation. Now, let's go to Section 103. Section 103 basically talks about the deadlocks in the management of the corporation. Kasi minsan hindi yan sila nagkakasundo. And mas madaling hindi magkasundo kapag kakilala mo. Kasi madali mo makausap. Lalo na pag business. Notwithstanding any contrary provision in the closed corporation's Articles of Incorporation, bylaws, or stockholders agreement, if the director or stockholders are so divided on the management of the corporation's business and affairs that the votes required for corporate action cannot be obtained. Ibig sabihin may deadlock. Hindi sila nagkakasundo. So stagnant yung corporation, stagnant yung operation. Kasi hindi sila mapagkasundo kung ano yung gagawin nila. With the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of the stockholders generally. So, ibig sabihin, may detrimental effect na sa kanila. Harmful effect Kasi hindi na mapapatakbo for the advantage of the stockholders. Kasi kailangan mo yung patakbuin for the advantage of stockholders para kumita kayo. Kasi yung purpose nila for profit. Kapag yun yung nangyari, may deadlock sa management, anong pwedeng gawin? Section 103 provides for that. The Commission, the Securities and Exchange Commission, upon written petition by any stockholders, shall have the power to arbitrate the dispute So pwedeng mag-intervene yung Securities Exchange Commission natin. Pero upon written petition by the stockholder, like sabi ni stockholder, "Oy, Commission, Securities Exchange Commission, may problema itong C corporation namin, itong closed corporation. May deadlock sa management. So kailangan namin ng intervention nyo para tapos medyo dehado na yung mga stockholders Stagnant na yung operations. So Securities Exchange Commission, Commissioner, please intervene now." O ganun, petition nila. Now, with that, the commission shall have the power to arbitrate the dispute. Now, in the exercise of such power, the Securities and Exchange Commission shall have the authority to make appropriate orders. So, ito yung mga listed na powers ni Securities and Exchange Commission kapag mag-i-interfere na siya, mag-i-intervene na as arbitrator. Una, the commission can cancel or alter any provisions contained sa Articles of Incorporation, bylaws, or any stockholders agreement. Yung stockholders agreement yung previous section. B, canceling, altering, or enjoining a resolution or act of the corporation or its board of directors, stockholders or officers. Another, letter C, the directing or prohibiting any persons party to the action, any act of the corporation or any party to the action. Ito pa, requiring the purchase at their value, etc. etc. Basta ito yung magiging power ni Securities and Exchange Commission kapag nag-intervene na siya as arbitrator. And makikita niyo dito, the commission can also appoint a provisional director. The commission, pwede niya rin i-dissolve yung corporation and granting such other relief as the circumstances may warrant. Ito pa, this second paragraph pertains to the nature of a provisional director when it comes to this concept or in this situation. A provisional director shall be an impartial person. So walang kinikilingan, walang pinoprotektahan, provisional director lamang, who is neither a stockholder nor a creditor of the corporation or any of its subsidiaries or affiliates, and whose further qualification. So as you can see here, wala siyang interest sa corporation kasi hindi siya stockholder, hindi siya creditor, wala siyang connection sa corporation, yung provisional director. So, para siyang independent director. Pero, provisional lang to siya for the meantime, habang may dispute pa yan sila sa deadlock ng management. And whose further qualifications, if any, may be determined by the commission. A provisional director is not a receiver. Kasi ang receiver sa'yo na mamahala sa liquidation ng corporation, sa dissolution ng corporation. Oo, madadaanan nyo yan pagdating sa insolvency. Sa insolvency law, yun. Pero ang receiver, basically, siya yung namamahala when it comes to the dissolution, liquidation of the corporation. Pero in this case, sabi dito, a provisional director is not a receiver of the corporation and does not have the title and powers of a custodian or receiver. A provisional director shall have all the rights and powers of a duly elected director, including the rights to be notified of and vote on a meeting of directors until removed. Pwede siyang tanggalin ng commission or by all the stockholders. So, pwede siyang tanggalin. Dalawang tao pwede pang tumanggal sa kanya, yung Securities and Exchange Commission, and by the will of all the stockholders. Sabi nila, ayaw nila sa kasi nakikita nila, medyo bias man yan. Pero kailangan all. Now, when it comes to the compensation of the provisional director, it shall be determined by the agreement between the director and the corporation, subject to the approval ng commission, which may fix for the compensation absent on agreement, etc. etc. So yan. We're talking about arbitration of intracorporate deadlocks by the Securities Exchange Commission. Now, if the directors or stockholders of a closed corporation are evenly divided, respecting the management of the corporation's business and affairs, deadlock sila and there's no way to settle the dispute, they may become deadlock. Walang mangyayari. Hindi uurong, hindi Tapos ang problema dyan, this situation may lead to paralyzation of the corporate operations, which mayroong detrimental effect yan Grave consequences to the members of the corporation. Kapag hindi na nag-ooperate, sayang ang kita. Walang profit. To avoid these consequences, yung mga detrimental negative effects na to, the Securities and Exchange Commission may intervene. Pwede makialam dyan si SEC. Upon written petition by any stockholder, with that, the Securities and Exchange Commission, the commission, shall have the power to arbitrate the dispute. Siya na yung mag-decide. O, parang judge yan sa dyan. Parang judge yung gagawin niya dyan. Titingnan niya, ano to? Ano to problema niyo dito? Ganun. The power given to the commission by this section 103 may be exercised notwithstanding any provision in the articles of incorporation or bylaws or agreements of the stockholders ng isang closed corporation to the contrary. So, with that, mas mananaig yung section 103 over sa provisions ng AOI, bylaws, or the stockholders agreement. In the exercise of its powers, the Commission may make such order as it seems appropriate under the circumstances, including the dissolution of the corporation. No? Itong kapangyarihan, no? And other reliefs na pwedeng i-grant ng Commission. The SEC may order the dissolution of the corporation if it will be beneficial to the stockholders and to creditors, but where the business is successful, it may appoint instead the provisional director as additional member of the board. O yan. The second paragraph talks about the provisional director. So yan, pag may deadlock, may problema sa management, hindi sila makadecide, pwede mag-intervene yung commission to arbitrate. Titingnan niya kung alin ba yung mas magandang decision in regards to the corporation na magiging beneficial to its stockholders, di ba? Kasi kawawa rin kailangan ng intervention kami from the government. Ito last section ng ng Title 12 natin, Section 104. Section 104 talks about the withdrawal of stockholder or dissolution of the corporation. Now, in addition and without prejudice to other rights and remedies available under this title, any stockholder of a closed corporation may, for any reason, compel the corporation to purchase shares held at fair value which shall not be less than the par or issued value, as long as the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. As you can see here, di ba sabi natin, a provision in the articles of incorporation stating that a stockholder shall need the consent of the directors and the other stockholders to transfer his shares is void, hindi valid. Hindi niya kailangan ng consent para mag-transfer ng kanyang shares. Kung gusto niya i-transfer yan, okay, goods, transfer niya. The only restriction, kailangan niya munang i-offer yan sa existing stockholders sa corporation. In this case, ganun yun. Pwede niyang i-demand, corporation, bili mo nga itong shares ko, purchase it at fair value, parang ganun. Or sa stockholders. But, purchase the shares held at fair value, which kung saan dapat hindi to mas mababa sa par or issued value. Kapag mas mababa yan, edi yung par or issued value mananaig. And another requirement, dapat may sufficient assets to cover the debts and liabilities. So parang parang same sa concept ng kailangan mo ng retained earnings, di ba? Parang ganun yan. Provided further that any stockholder of a closed corporation may, by written petition to the commission, compel the dissolution of the corporation whenever any of the acts of the directors, officers, or those in control of the corporation is illegal, fraudulent, dishonest, oppressive, or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being misapplied or wasted. So, dalawang nakikita natin dito. Yung right of withdrawal ni stockholder and yung dissolution ng corporation coming from the petition of a stockholder. So, right of stockholder to withdraw or have the corporation dissolved. So, the right of the stockholder to withdraw may be exercised for any reason. Hindi siya pwedeng i-prohibit na kailangan ng consent nito, kailangan ng consent ng mga directors, kailangan ng consent ng stockholders, bawal yun. He can exercise such withdrawal. Pwede niyang i-transfer for any reason. Trip niya lang. Or kailangan niya ng pera. Kaya kahit anong reason yan. Basta lang, ma-offer niya. Sa kanila niya i-offer. Preemptive right. Preemptive right. Right of first refusal tawag doon. Tandaan nyo, iba ang preemptive right, iba ang right of first refusal. Tandaan nyo yan, ang right of first refusal, it compels you to offer first the shares na gusto mong i-transfer, gusto mong i-benta to the existing stockholders or to the corporation. That is the right of first refusal. Ang preemptive right, it only talks about na dapat kapag mag-i-issue ng bagong shares ng corporation, sa'yo muna i-offer. Ganon yan ha. Right of first refusal, dapat kapag may transfer, mag-withdraw na sa corporation, either sa corporation or sa stockholders, existing stockholders na muna yan, i-offer. Yung preemptive right, it talks about the right na meron yung mga existing stockholders na kapag mag-i-issue ng bagong shares yung corporation, sa kanila muna, sa existing stockholders muna i-offer. So yan na. Huwag kayo mahilo sa difference ng dalawa. So on the other hand, his right to have the corporation dissolved by written petition to the executive sensei commission must be founded on some legal grounds mentioned. Ito, basically, kasi justifying dissolution by the commission which shall order the dissolution only after proper notice and hearing. So kasi dito, mga actions to na will have adverse effect to the interests of the corporation and or its stockholders. So since may adverse effect yan, sabi niya, kalokohan man tong ginagawa nila. May adverse effect to sa corporation. So before pa magkaroon ng malaking negative effect sa corporation, pwede yan sabihin na, sige, i-dissolve nyo na lang to kaysa i-continue nila yung kalokohan nila. O yan, written petition mo sa commission. Of course, magpaprovide ka ng evidence yan. Tapos, i-ano yan sa proper notice and hearing. Kung saan, mag-decide ang commission kung i-dissolve ba yan o hindi. Parang ganun. So, yan lang. Discussion natin. Title 11, Title 12. Title 11 talks about Title 11, non-stock corporation. Title 12 talks about the closed corporation. So, that is our discussion for this video. And, konting announcement lang para sa remaining schedules natin. Open ko ng calendar ko. So, dito, January tayo ngayon, no? So, gaya na sabi ko kanina, until Title 15 lang yung discussion natin. Kasi yung succeeding titles after that, hindi na siya necessarily important unless na law student ka. Kasi nasa procedural law na yon and other stuff. So, until Section 15 lang yung relevant para sa atin. And with that, may long quiz tayo sa January 15. Last long quiz natin or the fourth long quiz for this semester. Our last long quiz, ang coverage from Title 6 to Title 15. Sakto, January 15, Title 6 to Title 15. Sir, akala ko ba mag-ano ka ng natin sa cooperative? So, chill lang. Gagawa rin ako parang very short, short, kahit nga basahin nyo lang yung PowerPoint, goods na eh. But, very short lecture video for cooperatives. Basically, yung introduction niya. Kasi sa board exam, yes, merong questions sa cooperatives yun. Medyo sure ako around at least 4 yung naging question sa cooperatives out of 100 nung board exam namin 2018. So, kasama talaga yung cooperative. So, pero hindi yan kasama sa long exam natin sa January 15, yung topic ng cooperatives. Pero isasama natin yan sa ating final exam, which will be held on, i-announce ko na ngayon, January 22. Kasi di ba, ang finalist week natin is January 18 to January 23. So, yung schedule natin for our final exam for this subject will be on January 22, Friday. Tapos after nun, okay, 1 week sem break tayo, tapos balik ulit sa klase by February 1. Yawa. So, ano pa bang announcement natin? Yung tawag ito? Yung Create a Corporation, yung pinagawa ko sa inyo, similar sa Create a Partnership, yun, huwag nyo rin kalimutan. Tingnan nyo yung schedule of deadline. Make sure. So, yun lang, long quiz, make a corporation project, and final exam. So, with that, we end our lecture video for this session. So, have a good night. Have a nice sleep ahead. Goodbye. Bye-bye. Love you.